very much wondering, like, well, this is something which we really need in our Indian education system as of now. Like, we don't talk much about how to teach us this deep felt need. So when we assess a constitution, we have to assess the constitution by this criteria, like how far it gives student assembly. I'm not getting into the, in the intermediate, like there is an intermittent period in which there was a lot of confusion about what kind of a statement. It was followed by the presentation of the national flag. And the national flag was presented by Srimati Hansa Mehta because by an express declaration in April 2013 by the Government of India. So a dolphin, he enjoys protection under he or she what the constitution. When you look at that way in which it is stated, it appears as if it is kind of against equality. A kind of positive definition could have been, could have de Tocqueville. I have been, very much wondering, like, well, this is something which we really need in our Indian education system as of now. Like, we don't talk much about how to teach. We all discuss about what should be taught, what are the, kind of facts which should be delivered to the students. But when it comes to how to deliver it to the students, such discussions often, they really don't take place that much, and especially in the higher education sector. So in this context, I myself was privileged to conduct a national seminar or exclusively on the pedagogical aspect of political science from the discipline from which I came. So we had a session on how to teach Indian Constitution, which was delivered by Associate Professor Dr. Biju BL from Hyderabad Central University. So we were all trying to understand how to deliver it to the students, the kind of understanding we derive from these documents, how to approach these documents. So the basic idea of a constitution, itself is like when we discuss about how to take it to the students, the basic idea is to have the spirit that we don't have any kind of predetermined wisdom to guide us, basically, because there has to be a kind of discussion and initiative from the part of everybody to understand this document collectively and imparting this spirit to the people. That will be the success of a constitution, especially a democratic constitution. So today, I think we can have a kind of a general discussion about how will we go about it. I understand that our audience consists mostly of educators, and definitely this is a really very significant topic, and especially at this stage in which our Indian polity and society is there. This is a very significant issue to discuss about. So why do we need a constitution? This is the first thing which we need to understand. So usually we perceive it as the constitution is necessary so that we can prevent the abuse of powers by a ruler. There are two ways to look at it. So usually laws, they give power to the ruler, but at the same time, they curtail the power to the ruler. So it is often seen as a document which gives power, but at the same time, it limits power. Because if we look at history, mostly the rulers, the emperors, they enjoyed kind of absolute powers. At least theoretically, technically, they enjoyed unlimited powers. Practically, it was definitely constrained by a lot of limitations. We often imagine our earlier monarchies and other such forms of despotism to be of absolute power. But in practicality, all of them had a lot of limitations. They had to make a lot of concessions to the powers in the society, to cultural moods, to religious teachings. There were a lot of limitations, but technically they had an absolute power. But constitution somehow limits that power to the ruler, but it also limits the power of the people. In a way, we can, if I want to make it more clear, like constitution limits not only our ruler, it also limits us also from going in a very wrong direction. There is something called the tyranny of the majority. People themselves can go wrong. Always the majority might not be correct. The majority might go the wrong way. So the constitution sets a guideline which will ensure that not only the ruler, but also the population, both of them goes in the correct way. So that is the significance of the constitution. So there has to be some limit to the exercise of power. Excess of anything is quite bad. We have that very famous, uh, dictum given by Lord Acton. Power corrupts, absolute power corrupts absolutely. That's what he said. So that holds ground. So there is needs to be some kind of a limitation. Even in an absolute monarchy, there has to be a set of laws and rules which will guide the power, and that is more efficient. We all must have heard the story of the rabbit and the lion, how the clever rabbit guided the lion into the well. That's a very famous story of Panchatantra. We all know the story. I hope all of us know the story that of a lion. There was a lion. He was the king of the forest. He used to indiscriminately hunt all the animals. So the animals went to the lion and said that you should eat only one animal per day. And and the rest of the story is very known to us. But the interesting part, if you read the actual text of Panchatantra, the interesting part is there is a discussion going on between the lion and the subject animals. So it reflects something about the political idea of that times also, especially the Gupta period. So the animals are telling the king that, see, you should not eat us like this. They are not pleading for his mercy, but they are arguing on account of the sustainability of the process. They are saying that if you are eating us like this, the forest will be no more. It will be devoid of animals. So there has to be some rule and regulation. So you eat one animal per day, that will ensure that the forest remains, the animals survive. So there has to be a rule. So the animals say to the lion king, that the country should be enjoyed like a medicine. Rasayanam iva bhojyam. Rasayanam is a medication. So you have to consume it little by little. If you eat it all at once, you are going to suffer. So the kind of power should be limited, power should be curtailed, controlled, it should be exercised in a very limited manner. That understanding was there even in monarchies. So I think there is, so the significance of a constitutional document cannot be overemphasized. So it was very much part of the idea that there has to be some written rules and regulations to guide us. But then the basic uh, difference between a constitution during the time of the monarchs and the kings, and also that during democracy, is that its focus is different. What is it meant for? Whose welfare it is guided to? That is where a democratic constitution differs from other constitutions. So when we speak of democracy, we often give this definition, which was given by Abraham Lincoln. That's a very famous definition. Democracy is the rule of the people, by the people, government of the people, for the people, and by the people. Um, that is like a line that became famous. Actually, it went against the very prediction of Abraham Lincoln. Abraham Lincoln, when he actually gave the Gettysburg Address, he said that people might forget what I say today, but they will never forget what we did. But what he said was also that became a definition for a universal definition. So he was speaking in the context of the Civil War. He said people might not remember what I speak today, but people will definitely remember what we did. We definitely are not very familiar with the intense micro developments of American history, but this line became a kind of definition for democracy. And that definition, though appears quite banal today, kind of we have heard it everywhere, but it has some analytical potential if you look at it. It says democracy is the government of the people, for the people, and by the people. So if we look at the governments which are not democracies, we can see that almost all of them were, at least they declared themselves to be of the people and for the people. The operating word of a democracy is by the people. People are the operative element in a democracy. We have to act. We have to act to make a democracy possible. So there is some kind of, we are not passive recipients of the orders or passive recipient of, exercise of power. We are somebody who exercises power ourselves. We need to have our agency. So this agency part is very important as far as democracy is concerned. So um, in that way, the Constitution of India is a foundational text which addresses this deep felt need. So when we assess a constitution, we have to assess the constitution by this criteria, like how far it gives an opportunity for us to act as citizens, how far it prompts us to act as citizens, what kind of avenues it provides for us. So this is something which we need to assess about the Constitution of India. And another thing, why do we, like, for example, another thing is what is the relevance of the topic today? Like when we say how to decode the Constitution to the students, um, like sometimes people might feel like, does it need any kind of decoding? You can just read the document and understand it. But as a historical document, we can never understand it without the context. Now, if you look at Indian Constitution, if you read Article 52, just go to Article 52. It's a very cardinal, article. It says the executive, the president and the vice president. The president of India, there shall be a president of India. The executive power of the union shall be vested in the president and shall be exercised by him either directly or through officers subordinate to him in accordance with this constitution. So it says the executive power of the union will be, executed by will be used by the president, will be exercised by the president. And at other places, it says with the aid and advice of the Council of Ministers. But the Council of Ministers is also appointed by the President of India. So, which essentially, if you look at some people are jokingly saying this, that if somebody looks at this constitution alone, people might feel that we have a kind of presidential system where the president is ruling, because every single act in the constitution is done by the president. In fact, Babu Rajendra Prasad, he had some kind of an opinion that, see, I also have some kind of autonomy. President also has some kind of autonomy. I might exercise that. There were some kind of slight differences between Nehru and Rajendra Prasad on this account. And it was Ladi Krishnaswamy Iyengar who finally settled it. He said that no, the president, we are following the parliamentary system adopted from England, from the United Kingdom. So which means that the president can do no wrong. So he can never act without the aid and advice of the Council of Ministers. So that was settled forever. So that means without understanding the historical context, without being familiar with the context, a student can never understand the Constitution, even when things are quite explicitly stated. For example, if you look at this, provision, it is very clear. It has no vagueness. It expressly states the things, but the actual working is directly opposite to what is stated, in practice. So the president has, he has no powers. So this is applicable to all other provisions of the Constitution. So which means that if we are interpreting Constitution literally or as just a dead document, we are not going to get much out of it. So understanding the context, understanding the history is quite important in making sense of the Constitution. So when we look at so that's why I think definitely when we teach the Constitution, we definitely will have to visit the Constituent Assembly debates, which accompanied it, and the historical context of it. So if you look at the history of the Constitution making, we can see some foundational documents which preceded our Constitution, or even the background in which it developed. It did not developed in a day. Like, for example, we reached that goal itself step by step. So in 1885, we have the Indian National Congress being formed, and their demands were very minor and very meager. They were not asking for independence immediately. Even the very concept of India was, it was developing only. Even in 1928, when the Nehru report, it was Motilal Nehru who published a report, which was in the form of a kind of future constitution for India. We imagined that there shall be a king. There shall be a king. It's very interesting. The legislative power of the Commonwealth shall be vested in Parliament, which shall consist of the king, a Senate, and a House of Representatives, herein called the Parliament. So even in 1928, we had in our mind the concept of a king. So the Nehru report. So it spoke about the monarchy. It spoke about, it pleaded only for the dominant status for India. And we all know that in 1930, it was by 1930 that we had the Purna Swaraj Declaration, where we were confident enough to become we were confident enough to attain Purna Swaraj, or complete independence. So that was that other. It was a progress from the dominant status to the Purna Swaraj. And it was in the Karachi resolution, like it was in 1931. It was the Karachi resolution of the Congress, where uh, the movement was also from there were imaginations about what this independence should be. Like people were imagining what this independence should be, how we should go about it. And there the political, it was clearly stated that the political freedom, it should also include real economic freedom for the starving millions. So this idea was, attained in the uh, Karachi resolution. So you can see the step-by-step development of this political ideal. That in the first place we have the uh, Nehru report. Even before, there are many other documents before that, but I am just referring to the documents which are immediately relevant to our context. So there was the report of the Nehru report. Then it was followed by the Purna Swaraj resolution, where we declared that no, now we are going for complete freedom. There is no connection with the British. We are going for complete freedom. And it was just followed by the Karachi resolution, which explicitly stated that freedom does not mean simple political freedom. We also need economic freedom. So in this manner, there's a kind of an evolution. There's a proper evolution of the stand, where India became more and more assertive, and the ideological context of our constitution was formed. And the Constituent Assembly, I'm not getting into the, in the intermediate, like there is an intermittent period in which there were a lot of confusion about what kind of a state we should have, what kind of a federal system we should have. So I'm not getting into all those, things. But uh, the Constituent Assembly, when it was formed, um, that was formed in in the first meeting of the Constituent Assembly was on 9th December 1946. There are a lot of discussions about the representative character of the Constituent Assembly, whether it was really representative of the people of India, because there were many representatives who were not properly democratically elected. There were a lot of nominated members, and even the provincial elections, which resulted in the selection of these members of the Constituent Assembly, it was not based on adult franchise. People only, those who could pay taxes, only they could vote. So whether this really represented the people of India, that question was there. So, but we had to, like, history does not give us such, privileges. We have to work within the limitations imposed by history. So it was largely accepted that we have to follow this, assembly settings. But the members of the Constituent Assembly, to their credit, they lived up to the expectations of the Indian people. So when we look at the condition, when we go through the, great masterpieces written on the making of the Constitution, like Granul Austin, while they narrate the situation which was, in New Delhi at that time, the members of the Constituent Assembly were given special passes to get out of their houses. Curfew was imposed in Delhi at that time. The gutters of Delhi were literally, bloodied because of the communal riots. The situation was extremely tense. But even then, when we look at our constitution, it's it is, it embodies a spirit of brotherhood, embodies a spirit of fraternity. All these clashes, and there was a strong clash between Hindus and Muslims going on. There was a lot of bloodshed, rioting, everything was happening. Even then, they were not carried away by bigotry. They were not carried away by partisanship. That is something remarkable about the constitution, which we were able to make, in our Constituent Assembly. But that does not mean that our Constituent Assembly was a kind of very, peaceful place where everybody agreed to everything. It was not like that. I will come to that very shortly. Um, how that was achieved. It was not simply achieved in a, like, just because all the members were just thinking alike and they achieved the goal. It is not like that. So the Constituent Assembly, it worked for around 2 years and 11 months, and total of around 167 days to frame the Indian Constitution. And it could never have been possible if we did not have the experience of a large movement, which started from the 1880s. It extended till 1947. We had a long process. So that really helped us to reach the document of the Constitution. And as I said, the Constituent Assembly itself, it was not a very kind of a body which was, uh, completely peaceful or everybody agreeing to everything. It was not like that. It was a very, if you go through the debates, you can see that each of the provisions were counted and contested. All extremes were present. All extremes were present. We had R.V. Dhulekar, his Raghunath Vinayak Dhulekar. He was a member from the Jhansi. on a Congress party ticket, he came to the Constituent Assembly. And the discussion was about which language should be used for the making of the Constitution. So majority of the people, like those who are belonging to the non-Hindi states of India, they preferred English. And obviously, there are many people from Hindi-speaking states also. They also preferred English. There was a discussion, debate about it. R.V. Dhulekar was very, very strong in point. Actually, it is very interesting. He was a graduate in English. He had very good understanding of English, and he was a very, great person. He was a great educator also. But then he was speaking in Hindustani. So I think Sachidanand Sinha was in chair, and so he requested R.V. Dhulekar to speak in English. He said, persons from Madras, like Rajagopalachari, will be able to understand you, so you please speak in English. He said, I know English, but I will not speak in English. Those who don't know Hindustani should not be there in the Constituent Assembly. This is on record. This is in our Constituent Assembly debates. Those who don't know Hindustani should not be in the Constituent Assembly of India. That was the position. So there were such extreme opinions. But then that idea was not upheld. The Constituent Assembly, despite having a majority of people from Hindi-speaking states, the Constituent Assembly upheld the position that it should be made in English so that it will be accessible to all the people at that time. Whether English is truly representative of our culture, that's another thing. That's another thing we debated about. It is a colonial language. Definitely, Indian languages are preferable. But at that time, English was, for all practical purposes, it was the kind of lingua franca which could, unite people in India. So what I want to suggest was the same from the very question of the language, from the very question of the language to the question of each of the provisions and methods. There was a very strong debate within the Constituent Assembly. But all those debates were a kind of, they embodied the spirit of what S. Radhakrishnan termed as Samanvaya or Samavaya. Okay, so that is what I wanted to come to next. We all know the Tryst of Destiny speech, which was made by Jawaharlal Nehru. That's a very famous, very famous speech which was delivered in the Constituent Assembly. So that also, it also imbues the spirit of the Constitution. So all Indians should have equal rights. That's what, there are actually, when we look at the Constituent Assembly debates, there's a Hindustani part and there is an English part. Both parts are there. We usually, the English part is more famous, so we are more familiar with it. But there are some differences. It is not the exact reproduction of the text, but still there are differences in that. So where he clearly states that all Indians shall have equal rights. And, irrespective, and he said that India does not belong to any particular, any one party or group of people or caste. It does not belong to the followers of any particular religion. It's the country of all of every religion and creed. So it was very necessary to state that at that time, because there was a lot of tumultuous problems going on outside. And this statement, the Tryst with Destiny speech, it was seconded. We know all these things. The seconding does not happen automatically. It is already decided by the ruling party. So it was seconded by Chaudhry Khalikusaman. He was a member of Constituent Assembly from Uttar Pradesh, at that time United Provinces. Chaudhry Khalikusaman was there, and he seconded the Tryst with the Destiny speech. And later it was followed by the presentation of the national flag. And the national flag was presented by Srimati Hansa Mehta, because Sarojini Naidu was absent that day. So Hansa Mehta presented the Indian national flag, because for representing the women. So she expressly mentioned that, like, women, we own this nation. We we are very much part of this nation. So that was done. And then Vande Mataram was initially played before the beginning of the session. It was followed by Sare Jahan Se Achha and Jana Gana Mana. All of them. All the three songs were played. So that means, what you can say, the spirit of accommodation was there. In fact, as Radhakrishnan expressly spoke about it. And the approach was like, what should be our approach? Like every new nation, they have to decide upon what should be the course of, action they are going to take. What is the mode of action they are going to adopt? What are the values they are going to hold on to? So every nation has to decide on that. So India, in the Constituent Assembly, the position took was that we will take the spirit of Ashoka. That is why Ashoka's wheel was kept in the in the center of the flag. So Dharma Chakra was there, the Ashoka's wheel was there, and the idea was that Samavaya Eva Sadhu. You know, there should not be any discord. Concord is important. Bringing people together is important. So Samavaya Eva Sadhu, that was the kind of value which the Indian Constitution tried to uphold, Constitutional Assembly tried to uphold. And another idea was that of mridutva, mardavam, gentleness. So Radhakrishna, he actually quoted from Mahabharata while emphasizing the importance of gentleness, importance of softness. This is unlikely, especially after having a long nationalistic fight against the British. You don't expect the assembly, the members of your constituent assembly to speak on softness and gentleness. It should be like kind of, we have won the freedom. We have to fight for our nation. We are the warriors. That was not the spirit. The spirit was like, we definitely have suffered a lot. We have toiled a lot. We have gained this freedom, but we have to exercise it with caution. We have to exercise it with responsibility. So what he said was, Mriduna darunam hanti, Mriduna hantya darunam, nasadhyam mriduna kinchit, tasmat tikshnataro mridu. Like Mriduna darunam hanti, the hard one is defeated by the soft one. Mriduna darunam hanti, Mriduna hantya darunam. Even those which things are gentle things are also won by gentle things. Nasadhyam mriduna kinchit. There is nothing which we could not achieve. There is nothing which we could not achieve with softness. Means softness can achieve anything. Nasadhyam mriduna kinchit. Tasmat tikshnataro mridu. So that's why. So he says that the gentle one, the gentleness is even more stronger than hardness. It's harder than hardness. That was the idea. It is stronger than hardness. So gentleness was adopted. It was considered as a strength to be gentle. And that was the spirit which imbued our constitution. So when we go and read the provisions of the constitution, when we interpret the constitution, all of them has to be looked at in that light. So I think that is largely about the making of the constitution. And I can never overemphasize how significant it is. We should go through the provisions. Complete reading of the Constituent Assembly debates is kind of impossible. It is well nigh impossible because it's a very elaborate document. We have to, but at least selected parts could be read. Initial parts could be read, and it could be introduced to the students also. Another interesting exercise will be to give them to take discussions which are specific to the articles and give to them so that they can read those parts and then discuss about it, have discussions about it. And then that reveals many things about the fundamental about the rights which are about the the context in which those articles evolved. For example, if you look at right against untouchability, we have it in Article 17, right against untouchability. Untouchability in any form shall be punishable. And that is a right which actually extends not only against the state, but it also extends against the individuals. Like even in our private spaces, we cannot practice untouchability. It's prohibited in India. So this is a right which is available against the individual persons also. Usually all the rights come from the state against are set against the state. So when we look at this provision of untouchability, when we look at the discussion in the Constituent Assembly, we can see that untouchability is not clearly, it's not defined in the Constitution. It is left to the, it is considered as to be understood. They don't say untouchability arising out of caste discrimination or anything. But there was a very strong argument on the part of the members that the untouchability faced by women during the menstruation period, menstrual period, that should be considered as, that should also be included expressly in the untouchability provision. So that kind of a discussion. So it had to be like, the gender aspect. We usually take untouchability in the caste aspect, but the untouchability in the gender aspect also, that was also considered, to be a valid ground, by the Constituent Assembly members. So when we go through the debates, that expands the, that gives us more insight into how provisions are made. And I think when we teach to the students, there are, it should not be. I believe that when we teach the articles of the Constitution, we should never teach them in a kind of it's a very dry. It will be very dry to teach it in very legal, and we should always be kind of imaginative. Try how to expand its dimensions, thinking experiments. And Indian Constitution gives a lot of space for that. For example, if we take Article 14, right to equality. Right to equality is defined as something which is available to all persons. So irrespective of citizenship, irrespective of caste, creed, religion, and all, it is available to all persons. So even a foreigner, even a person who is not a citizen of the country, he is given the right to equality. But interestingly, it is given to all persons, which means that not only human beings, but even those who are not human beings and which are legally considered as persons, they are also, they will also be able to avail the benefits of right to equality. So we can ask the students, like, which are do you think there are any persons who are not human beings? Do we have non-human persons? Definitely, we have non-human persons, like legal fictions. For example, in the recent case in Ayodhya, Ram was a legal, person, even though he is not a real, person with flesh and blood. It was considered as a legal kind of person. And another thing is dolphins, whales, and animals which belong to the Cetacea group of biological order. They were considered as persons by an express declaration in April 2013 by the government of India. So a dolphin, he or she, whatever, enjoys protection under Article 14 of the Constitution of India. So which means that we can never own a dolphin. We cannot keep a dolphin as a pet, and we cannot own a dolphin because it is a person now. So it can never be a slave to another person. It cannot live for another person. So this aspect will be brought in. You know how broad it is, how broad its scope is. A kind of universal vision which imbues, the Constitution of India. So these articles, so I'm just giving an article. And another thing is, um, the very idea of the Constitution is to instill a critical spirit in us. So Constitution, definitely we need to respect it, but at the same time, the Constitution has to be looked at with a critical eye also. There has to be critical provisions. There has to be, if we definitely freedom. Constitution itself gives us the freedom to criticize the Constitution. For example, if you take Article 14 itself, you find that affirmative action for women and children, that is stated as an exception. Like, it is treated as something which is kind of against the article. Like, for example, the Article 14 states that no person shall be denied equality before law or equal protection of law. That is stated. Then Article 15, it says that there shall be no discrimination on the basis of caste, religion, creed, or anything. There will be no discrimination practiced by the state. But then there is an exception to that. As 15.3, as an exception, the 15.3 says that any action taken by the state for the special protection of women and children, that is not to be considered as against or violative of this article, which means that the foundational definition of equality does not, include the special protection of women and children. So this resulted in a lot of, actually, we know there's a lot of anti-reservation sentiments when it comes to reservation for women, when it comes to reservation for SC, ST, OBCs, and also reservation to economically weaker sections of the society. We definitely face a lot of opposition. And I believe that the way in which it was stated in the Constitution, when you look at that, way in which it is stated, it appears as if it is kind of against equality. A kind of positive definition could have been, established. It could have been defined in other ways. It could have been defined in a kind of positive way. Equality could have been the definition is still there, but still it could have been defined in a positive way. And these measures should not have been stated as exceptions. Their applicabilities could be, how far how we should employ this provision, that should be discussed and debated. But still, stating them as exceptions was not the right thing to do. So this kind of things are there, but still our constitution, if you look at the, in general, if you look at it, was a very bold step taken by a nascent, country. And another thing which I observed in the constitutional document is its constant emphasis on Vishwa Kalyan, or world peace. No, we are not simply concerned about ourselves. We are always concerned about humankind. We are concerned about the world affairs of the entire humanity. And possibly that was I think, the success of Indian democracy possibly rested on this emphasis. Sorry. We Indian people are all very much, many times, we are very critical of ourselves. We often say that, especially I think in Kerala also we have the sentiment like, I see we are a third world country, undeveloped, we are not doing well. But when we look at the history of the world, our country has achieved something very remarkable. If you look at the other nations who became independent along with us, many of them went into autocratic rule, despotism, and a continuity of electoral, at least electoral democracy, at least procedural democracy, is something which India has achieved. And definitely that credit goes to the Constitution of India, it being accommodative, it having the provisions to accommodate this diversity. So the design of the Constitution was in such a way that this diversity is celebrated. That is what the point made by Yogendra Yadav while he was giving a lecture on the nature of Indian Constitution, where he made this point that, see, Indian Constitution is extremely centralized when it comes to the federal structure, as far as the federal values are concerned. You know that the states could be made and unmade in seconds. A parliament can make the constitution, a parliament can make the state or unmake the state in minutes. So simple. They have no constitutional protection. For example, if the parliament wants, it can definitely split Kerala into two. There could be three Kerala's made. Nobody could question. Any state could be combined. The only thing that the constitution states is that India shall be a union of states. So that means there should be at least two states. That is what we can say. So that much, there should be a union of states. So there should be at least two states should be there. That's the only thing. Or what should be the name? What should be the territory? Everything is left to the parliament. Absolute freedom. That was the only thing which was possible at that period. But if you look at other provisions also, they are kind of, there is a lot of centralization at the administrative level. But if you look at the cultural level, if you look at the political, and if you look at the cultural level, if you look at the linguistic and other aspects of it, that celebrates diversity, maximizing diversity. Let there be diversity. It is seen as a strength. So maximum freedom, special protection to minorities, special protection to religious minorities, linguistic minorities, the right for them to preserve their script and their culture. So that kind of thing is there. So on the one hand, we have a celebration of diversity at cultural level and other aspects. On the other hand, in politically, we have a very centralized form of governance. So this condition was there, and this design worked. It really worked for a long time. But there definitely needs some changes, which we can discuss. If we have time for discussion, we can go for it also. I think I should conclude within 2 or 3 minutes. Should I?
Yes, sir. Maybe we can take another 5 minutes. Yeah.
Okay, fine. So the idea is that, see, our constitutional design, it worked, it performed well. So what were its strengths and what were its weaknesses? And it definitely needs updation. And if it needs updation, in what sense? For example, now think of the states of India. While the states were being formed, uh, they were they hardly had the kind of stability which they have today. Which we assume to have today. Like Kerala was formed in 1956. Now Kerala has emerged as a kind of a distinct identity, and it is lot more responsible for people's lives. Now, for example, if you look at a state of India, any state, Uttar Pradesh or Gujarat or Kerala or any state, Tamil Nadu or any state, people look up to the state for their primary needs. For example, about health, education, local roads, and other things. The blame is on the state government. It never goes to the central government. For example, if you don't have a medicine in your primary health center, you will not complain to Mansukh Mandavyaji. He is the union health minister. But he is not concerned. If your district hospital, even though there is a district panchayat, nobody will ask the district panchayat. Definitely the blame will go to the state health minister. So the states have a lot of responsibilities. They have a lot of welfare functions to meet, but our constitution does not give that much resources to the states. That allocation is not there. I definitely agree that at that point of history, this was the best possible arrangement which they could achieve it. But today, the situation has changed. The states have become, they have become entities which have a lot of responsibilities, a lot of, kind of, cultural, capacities. So there are much more demands they have to meet. So in this aspect, for example, this is one aspect where I think Indian Constitution needs to think about, what should be a better possible arrangement as far as the rights of the states are concerned, resources that could be allocated to the states are concerned. And in that part, I think, we can, we have to critically assess the Constitution. What improvement could be made? So in this way, the Constitution of India, that's a living document. In fact, when Granville Aston, he wrote the, book, very famous, Working a Democratic Constitution. Working a Democratic Constitution. Why he wrote it? He titled it like, why didn't, like, he explains why he put the title as Working a Democratic Constitution and not Working of a Democratic Constitution. Because he said that a constitution will never work by itself. It has to be worked. You have to make it work. So as a document, as a historic document, we can, we need to work a constitution. We have to make a constitution work. So in that way, I think Indian Constitution is here to stay, and it is definitely a document which teaches us a lot about, it teaches us a lot about the, I will come to that later. I could not get into that, personally, but sorry, the other aspect of it. For example, it teaches us about personal values. That's on like constitutionalism. I will come to that later. For about parliamentary democracy, about constitution, what it has for our personal lives. I think that we had the political part was discussed, but personally also constitution teaches us a lot about some values. So that we will discuss later. Like, there are some values which you could adopt in our personal lives also from constitution. Constitution teaches us, how to listen to others. So whenever you have a debate in the parliamentary system, it is always expected that there is an opposition. So whenever we state anything in the parliament, definitely the system itself expects a response from the opposition. There has to be an opposition to it, and definitely this has a lot to do. It will help a lot in the democratic working of the institutions and the decisions which we make in our personal lives. The working of the the family itself. The spirit of the constitution can definitely be a guiding light for all of us.
Sir, we have our first question. How can we stop the constitution from being tampered with?
The question is very relevant because the constitution makers, they were also very concerned about this, this question. Ultimately speaking, we know that Parliament is the ultimate authority of the constitution. It can make or unmake the constitution. As of now, we have the doctrine of basic structure. The Supreme Court of India says that there are some basic features of the constitution which cannot be altered even by the Parliament. For example, right to equality, the election of the president, the federal system. These are things which even a parliament, technically it can change it, but legally at this point, the Supreme Court has said it cannot be changed. The basic structure is there. But the constitution is a living document, So constitution is a living document, and hence, as I have earlier said, we can never preserve a constitution unless we have a kind of eternal vigilance on our part. Unless we have active citizenship, it is very difficult to protect it as a, as a, what do you say? There cannot be, it cannot be in a vacuum. It is always interacting with the environment. You have to play an active part to preserve the constitution. And if the moment you lower your guards, definitely it will be overtaken, it will be tampered with. There is no doubt about it. If you look at, I wanted to actually talk about this point in the lecture also. You must have heard of a book, Democracy in America. It was written by Alexis de Tocqueville. It is considered as one of the best works regarding America and also about democracy, the best work regarding democracy. So it was like that. So in this book, uh, he narrates an incident. We know that America is a land which had the first written constitution in the world. In 1776, they had the written constitution, written proper constitutional democracy. Um, so he was narrating an experience. He went to the polling booth, and the blacks of the United States of America, they had the right to vote in 1812. This is happening in 1812, and he asked somebody, uh, like America is such a great democracy, but why the blacks are given no powers? Why they are not given any equality? The other person responded, do you think we cannot, do you think we are that much disgraceful that we will not give equal rights to the blacks? There is no question of racism in America. Blacks have equal powers in everything. We are or all free people. All of them have the right to vote. Then he asked, then why do I not see even one black person in the polling booth? Not even one person is coming up. Then the other person responded that, see, they don't want a confrontation because the people are not ready to let them vote. There will be a confrontation. So they have willfully decided not to come for vote. So, in fact, it is only in 1965, like even after 1965, that that America ensured equal rights to vote to all people, because till then different states had different rules and which indirectly tried to curb the voting power of black people. It was only in 1965 that Nixon signed the act which ensured that all people, irrespective of in any kind of educational qualification, there was even things called grandfather clause, like you can be a voter only if your grandfather was a voter. Those kind of things were brought in. So it was only in 1965 that a complete franchise was given to all Americans. My point is that by bringing something in the Constitution, that is not a guarantee that it will be implemented. In fact, another interesting thing is, the Statue of Liberty. It is the statue of a woman carrying the flame of liberty. The very inauguration of that function, the function in which the inauguration happened, women who were unaccompanied by men were not allowed to participate. So the women rights activists of America, they had to. It happened in an island. That statue is erected in an island. So the women activists, equal right activists, they had to hire a boat so that they could witness the inauguration from the sea, because they were not ready to. They wanted to go alone. They wanted to go unaccompanied by men, but it was not allowed. They were not given tickets, so they had to rent a boat and they have to witness it from the sea. The Statue of Liberty, which is a statue of a woman holding the flame of liberty, the women had no liberty to buy tickets to the event on their own. So, which means this is also from America. So the thing is, having something in the Constitution is no guarantee that it will be given to us. So people will have to be active. There has to be, and that's why I think this kind of discussions and debates in the spirit of the Constitution is very important.
Thank you, sir, for that. We have a question from Shipra. Sir, though directive principle of state policy uh, is the soul of the Constitution, she requests you to focus upon this term to herald and enrich the knowledge.
Okay. Directive principles of state policy. See, as I have already stated, um, there was a lot of conflict in our Constituent Assembly regarding the path we should take. Um, in 1928, we spoke of Dominion status, and in 1930, we spoke of Purna Swaraj. And in 31, we spoke of economic freedom. And if we look at the situation outside India, that was also, it's a kind of tumultuous situation. A lot of changes happening in the world. In 1917, there was the Russian Revolution. USSR was coming there. There were the Great Depression was in America. The capitalist world was facing a crisis. And in Constituent Assembly itself, there was a concern that India might face a kind of rebellion from the people, the kind of which was witnessed in other parts of the world. So it has to be the economic needs of the people they have to be addressed. Otherwise, it will result in the splintering of the nation. But then the counter argument was that the nation cannot guarantee something which it cannot provide at this point, because India is a very poor nation. So providing all these things universally, it might not be feasible economically. It might not be feasible, for the state as of immediately. But at the same time, the needs of the people, they have to be respected. It has to be taken care of. And another factor was that the zamindars, the rulers of the princely states, and they were all against the kind of principles which will, kind of socialistic principles. So there was a kind of clash, which was going on. India had made a lot of, in fact, they have achieved the kind of state which we have today. It is a product of a lot of compromise, a lot of concessions. In fact, we had Raja Pramukhs for a long time. Instead of governors, we had Raja Pramukh. The erstwhile royal people, they were given privy pension. Special money was given to them for a long time so that they will be willing to join. Many compromises were made. So directive principles was seen as a kind of a place where all those principles were included, which were not immediately attainable by the state. But if you look at the history of Indian Constitution, things in directive principles, some of them have later gone into the fundamental rights. For example, right to education. Right to education was initially there in the directive principles, so it went to the fundamental rights. So in that way, it is expanding. There are a lot of challenges still. Um, so that is it. The way in which the state is expected to function. There are people who argue that directive principles as a chapter, it needs much more editing. Because it's a product where kind of all those things which were not acceptable immediately, we put them into the if you go through the chapter, we will definitely, a language editor will always feel that, see, I need to do some serious work on this part. There are kind of repetitions. Those things are there. But what I have found is that there is a tendency of directive principles to move into the fundamental rights part of the constitution, and I hope that more directive principles will come as legally justiciable in future.
Thank you, sir, for that. There's another question from Rugmani. Don't you think that the reservation provided by the Constitution must be based on the economic conditions of the individual?
Yeah, that is a very serious, long, and that's a very long debate, which I would not be able to address in. I might be able to state my opinion, but to address that question in its entirety will be very difficult. It's a long-ranging debate. But still, I would just, very, very, very briefly, I would just state this: that if we take up, we often think that the kind of economic conditions. Suppose there are three groups of people in society. Let us say A, B, C. So you find that people from Group B and Group C are being underrepresented in education, in government jobs, and many other things. And people from Group A, they are predominantly present predominantly successful in these areas. So what could be the logical conclusion? There could be two, things. Either we can say that the people belonging to Group B and Group C they have less intelligence. That will be racist, to say. Or we can say that the socio-economic conditions which Group B and C are facing, that is preventing them from being successful in education or in getting jobs. So there has to be a special, measure. So that is the spirit in which the Constitution has granted reservation based on social and educational backwardness. We say that we often think that it is caste based or religion based. It is not that. It is not based on caste or religion. It is based on social and educational backwardness. And that's why when we wanted to bring economic reservation, we had to amend the constitution to add clause 15(6). We had to add another exception that economically weaker sections will also be given reservation, because originally it was for social and educational backwardness. And I think even today there are, for example, if you go through the newspapers and all, there are plenty of incidents of caste violence. Caste was not simply a social institution; it was also an economic institution. So that is a long debate. I know, there has to be a much longer. This will never satisfy. This question. We can have a separate session on that. We can have a discussion on that. This is my primary opinion. Yeah.
Thank you, sir, for that. We have another question here from Shipra. Whether the FRS and DPSPs go hand in hand. That's inseparable in nature from each other.
Yeah. Originally, they were supposed to be, um, both of them were supposed to be fundamental, fundamental principles. In fact, if you look at some of the documents I have mentioned earlier, they are not making any distinction between social economic rights and political and civil rights. The initial documents of the Constitution of India. Later, this clash came. A larger section of the population, for example, the Zamindars, they had a very good hold on the Constituent Assembly. They were, uh, the bourgeois class. If you look at the rich class, the business class was very small at that point. They did not have that kind of a presence in that way. They cannot that kind of a presence was not there. But the fundamental rights and directive principles of state policy were not initially considered as two separate things. They were considered as they were taken as one. It was only a compromise. We had to had a compromise at that point, and that's why directive principles went into another chapter. So if you look at the UN resolutions, you have the UN charters, United Nations charters. They don't make any kind of distinctions between these, in value. Both of them are considered as sacred: civil and political rights, and economic and social and economic rights, both are considered equally sacred. And in fact, if you look at the way the world develops, even countries like United States, which are like very big capitalist nations, even they are thinking about introducing a universal basic income. A universal basic income. There are strong demands for that, because the world is becoming so resourceful, and wealth inequality is hugely increasing, and there are strong arguments for a universal basic income. So I definitely think that this distinction between fundamental rights and directive principles itself, it might vanish in the coming days. That's what I feel.
Thank you, sir, for that. We have one more question. Constitution is not an interesting subject if only the articles are taught. So if we bring to history and context, the study should become interdisciplinary. So what is the approach teachers would take?
Sorry, could you repeat the question?
Yes, sir. Constitution is not an interesting subject if only the articles are taught. So if you have to bring history and context, the study should become interdisciplinary. So what is the approach the teachers could take?
Yeah. In fact, that is the way social sciences itself, is the social sciences themselves are moving in that way, in the interdisciplinary way. And as I have already stated, that was the point of my, the presentation itself was that we can never understand the Constitution in a vacuum. We can never understand it as a literary, just literary document. We will have to go into the historical context, how each provision was formed, how each provision was, and definitely it will be useful when you teach to the students. It will be really helpful. For example, the kind of the documents which I have mentioned, for example, Panchatandra. Panchatandra takes a lot of, when I read Panchatandra in the original, not in the Amar Chitragatha way, but if you go to the text and read the text, we will definitely find a lot of illustrations which will help us to enlighten our students and make them interesting. For example, the story I mentioned. Usually that story is told like, the rabbit is very clever. He showed the well to the lion, and the lion jumped into the well, and everything went, well. But other thing, but if you read the actual thing, there's a great debate about the state, cult and all. These things could be brought into the class, I think, in that way. For example, when we speak about the sovereignty, when we teach preamble, we say, "We the people of India." What is the significance of that? Earlier, people were not an element. Um, Sovereignty was not, the state had no sovereignty. States were almost the possession of the kings. You must have heard the problem of enclaves between Bangladesh and India. Enclave problem. Like India had some villages in the Bangladeshi territory, like they were Indian villages owned by India. And in the same way, Bangladesh had some enclaves within Indian border, which was technically Bangladesh. And the people who are Bangladeshis, they could not get out of their villages because outside is India. There's a story, like it's not actual historical thing, but there's a story which says that there was Rangpur and Kuch Bihar, two states, two princely states. So the kings of these two states, they used to play, they used to play chess. They used to play chess and all. So they used to keep the villages as a kind of pawn, kind of betting thing. So when the Rangpur Nawab loses, he will give some villages to the Kuch Bihar king. When the Kuch Bihar king loses, he will give some states to the Rangpur Nawab. So in this way, they exchanged these villages. And what happened when the Indian independence was achieved? Kuch Bihar joined India. Rangpur joined India. Kuch Bihar went to Bangladesh. So what happened was with that these villages also moved. So the Indian villages were in Bangladesh, and Bangladeshi villages were in India. So what this says about the nature of sovereignty? What is the difference? Now today, if our prime minister is playing chess with another prime minister, he can never gift a part of land because land is considered as sovereign in itself. It does not belong to the ruler. The territory of India, it does not belong to a particular government. It itself has a kind of sovereignty. So that is a kind of way in which we can illustrate this principle. So history helps us. History helps us. So I think that kind of an approach should be taken. We have a lot of resources to draw from history, and that will make it interesting. And also our assembly debates, constituent assembly debates. They are the real things. When you teach articles, definitely go into the debates. You will definitely find a lot of interesting things to speak about.
Thank you, sir, for that. There's one more question from Shipra. Um, in our FDs, though non-forcible, but exactly what does means the developing scientific temper being citizen of India?
Okay. Developing scientific temper was part of the fundamental, it is a part of the fundamental duties as 51A. We have it, it is made the duty of every Indian citizen to have, to develop scientific temper. In fact, this scientific temper itself was a kind of a gift by the word I'm saying about the word. It was a gift by Jawaharlal Nehru. He coined it. In fact, if you look at the initial periods of Indian history, we still have them. Nobody talks about them. We had Vigyan Mandir. Mandir is a temple. Vigyan is science. We had temples of science established by Nehru. Like people say that dams were the temples. That statement is very famous. Jawaharlal Nehru made this statement that dams are the temples of modern India. But he actually established Vigyan Mandirs, science temples, where popular science centers where people will go and learn science. So this need was definitely felt that we have to bring people into modernity. Modernity is different from simply being contemporaneous. Like I think that distinction has to be clear. Modernity, modernization, modernism, these are all different things. People often confuse modern with new. Modern is not about new, not about being new. Modern is about being enlightened. Modern is about developing the capacity to think for yourself. That is a key aspect of it. So when we say scientific temper, what is the what makes something scientific? It was defined by Immanuel Kant in his very famous essay, What is Enlightenment? What is Enlightenment? Vasist of Clarum, where he stated that a man is enlightened when he can think for himself, when he is confident enough, sapere aude, like dare to know. So if we are courageous enough to know, if we are courageous enough to inquire, then we will be free, then we will be enlightened. So a constitution can never work. I'm telling you, a democratic constitution can never work without an enlightened people. Unless the people start demanding, unless the people start exercising their rights, we will never be able to, get that, it cannot work, that this constitution will not work. So it necessarily presupposes an educated, enlightened population. Democracy necessarily presupposes an educated and enlightened population. So a scientific temper is something which is of a key element of being, a citizen of India.